Hi friends, I am Jagdish Khobragade, Assistant Professor at School of Law, Dr. HARISINGH, GOUR, VISHWAVIDYALAYA, SAGAR, Madhya Pradesh. Today's topic of our discussion and learning is all about essential commodities. This lecture is divided into 6 modules. Module 1, Introduction and Overview of Essential Commodity Act. Module 2, Objective of Essential Commodity Act. Module 3, Structure of Essential Commodity Act. Module 4, Amendments of Essential Commodity Act. Module 5, Penalties and Punishment under the Essential Commodity Act, and Module 6, that is Conclusion. Today we are going to learn about the Essential Commodities Act 1955. In this lecture we are going to discuss about basic needs of human beings. What is essential commodity? Why rules for essential commodities? Why law is required for regulating essential commodities? And what are penalties for violation of this act? In 1939, the Government of India made certain rules to control the production, supply and distribution of certain commodities under the Defence of India Act, which ceased to have force in September 1946. Thereafter, it was considered necessary that the control in respect of essential commodities for human beings should continue in the interest of general public. Therefore, the Essential Supplies Temporary Powers Ordinance 27 of 1946 was promulgated, by which certain provisions of Defence of India rules continue to have force. This ordinance was subsequently replaced by the Essential Supplies Temporary Powers Act 1946. The operation of the 1946 Act was prolonged up to 1st April 1948. By virtue of the notification published in the Official Gazette of India dated March 8, 1947, under the certain resolution of the Constituent Assembly passed in 1948 and 1949, and by the adoption of the Laws Act 1950, the operation of the Act was further extended to different periods from time to time, since in the public interest it was considered that the centre should continue to control production, supply and distribution of certain essential commodities, and the need of the Act was felt. For this purpose, certain amendments were required to be made in the Constitution. The Constitution 3rd Amendment Act made the required amendments in entry 33 of list 3 of the 7th schedule to the Constitution to enable the Parliament to enact the required legislation. The Essential Commodities Ordinance number 1 of 1955 was therefore promulgated, which came into force on 26 January 1955. This ordinance was subsequently replaced by the present Act, namely the Essential Commodities Act 1955, with effect from 1st April 1955. Under chapter 2nd, we will discuss objective of the Essential Commodity Act. The preamble to the Act says that it is an act to provide in the interest of general public for the control of the production, supply and distribution of certain essential commodities. The dominant object of the Act is to secure equitable distribution and availability at fair prices of essential commodities in the interest of general public. The Essential Commodities Act 1955 was enacted to ensure the easy availability of essential commodities to the consumers and to protect them from exploitation by corrupt traders. The Act provides for regulation and control of production, distribution and pricing of commodities which are declared as essential for maintaining or equitable distribution and availability at fair prices. The Essential Commodities Act is being implemented by the state government, union territory administration by availing of the delegated powers under the Act. The state government and union territory administrations have issued various control orders for regulation production and distribution of essential commodities such as food grains, edible oils, pulses, kerosene, sugar, onion, potatoes, etc. The central government regularly monitors the action taken by the state governments, union territory administration to implement the provisions of the Essential Commodity Act 1955. The items declared as essential commodities under the Essential Commodities Act are reviewed from time to time in the light of liberalized economic policies in consultation with ministries, departments administering the essential commodities, and particularly with regard to their production, demand and supply, etc. Under chapter 3, we will discuss the structure of Essential Commodities Act. The Essential Commodities Act 1955 provides total 16 sections. Section 1 provides application of this act to the whole of India. Section 2 provides definition, and under that section 2 clause 1a defines collector, which includes an additional collector and such other officer not below the rank of subdivisional officer as may be authorized to perform the functions and exercise the powers of the collector under the act. Section 2 clause B provides food crops include crops of sugar cane. Clause C provides notified order, means an order notified in the official gazette. Clause CC provides order, includes a direction issued thereunder. Clause D provides state government in relation to a union territory, means the administrator thereof. And clause E provides definition of sugar, which means any form of sugar containing more than 90% of sugar rose, including sugar candy, khandsari sugar or bura sugar or crushed sugar or any sugar in crystalline or powder form, or sugar in process in vacuum pan sugar, factory or raw sugar produced therein. Essential Commodities Act provides under section 2 clause A the declaration of essential commodities, which defines the essential commodity means and commodity specified in the schedule. 1. Drugs. The explanation clarifies that for the purpose of this schedule, drugs has the meaning assigned to it in clause B of section 3 of the Drugs and Cosmetics Act 1940. 2. Fertilizer, whether inorganic or organic or mixed. 3. Foodstuffs, including edible oils and oils. 4. Hank yarn made wholly from cotton. 5th. Petroleum and petroleum products. 6. Raw jute and jute textile. And 7. Seeds of food crops and seeds of fruits and vegetables. It includes seeds of cattle fodder, jute seeds, etc. And 8. Any other classes of commodity which the central government may by notified order declare to be an essential commodity for the purpose of this act, being a commodity with respect to which Parliament has power to make laws by virtue of entry 33 in list 3 in the 7th schedule to the Constitution. Under chapter 4, we will discuss various authorities under the Act and its powers. Necessary powers have been given to the central government under the Act to administer the provisions of the Act by issuing orders, directions notified in the official gazette, and by delegating the authority to the state government and union territory administrators. The central government at its apex level is responsible for achieving the objectives enshrined by the Parliament under this Act for the welfare and general well-being of all the citizens. Section 3 provides powers of central government to control production, supply and distribution of essential commodities. Power to issue orders of the central government having been vested with the power under section 3 clause 1, which can issue an order in the following circumstances providing for regulating or prohibiting the production, supply and distribution of essential commodities, trade and commerce therein. That is number 1, when it is necessary or expedient for maintaining or increasing supplies of any essential commodity, or second, for securing the equitable distribution and availability of essential commodities at fair prices, and 3, for securing any essential commodity for the defense of India or the efficient conduct of military operations. The content of the order provides that, notwithstanding the above and without prejudice to the generality of the powers contained in subsection 1 above, subsection 2 of section 3 provides that the central government may issue an order which may provide all kinds of order which are required for implementation of this act. Section 3 clause 3 vests power in central government to deal with the pricing of the essential commodities, particularly when the commodities are being sold to central or state government in compliance of the order under clause F of subsection 2 of section 3. Section 3 clause 3a clause 1 empowers the central government to direct the price at which the foodstuffs in any locality will be sold to the general public. This direction will be issued only when central government is of the opinion that taking such steps is necessary for controlling price rise or preventing the hoarding of any foodstuffs in any locality. The Essential Commodities Amendment Act 1976 inserted subsection 3b in substitution of the then existing section providing for payment of procurement price of such food grains, edible oils or oil seeds as may be specified by the state government with the prior approval of the central government. Subsection 3c of section 3 provides fixing price for sugar to be paid to the producer. In terms of subsection 3e, the central government has been empowered to direct from time to time by general or special order any producer or importer or exporter or recognized dealer or any class of producers or recognized dealers to take action regarding production, maintenance of stocks, storage, sale, grading, packing, making, weighting, disposal, delivery and distribution of any kind of sugar in the manner specified in the direction. The central government has been vested with necessary powers under subsection 4 of section 3 to authorize any person known as authorized controller when it is considered necessary for maintaining or increasing the production and supply of essential commodities. The authorized controller shall exercise such functions of control as may be provided in the order with respect to whole or any part of such undertaking engaged in the production and supply of the commodity. An order made under section 3 of the Act shall be issued and served in the manner as provided under section 3 clause 5, that is in the following manner: A. In the case of an order of general nature or affecting a class of persons be notified in the official gazette, and B. In the case of an order directed to a specified individual be served on such individual, or by delivering or tendering it to that individual, or if it cannot be so delivered or tendered, by affixing it on outer door or some other auspicious part of the premises in which that individual lives, and written report thereof shall be prepared and witnessed by 2 persons living in the neighborhood. Section 4 of the Act provides that an order made under Section 3 may confer powers and imposes duties upon the central government or the state government or the officers and authorities of the central government or the state government, and may contain directions to any state government or the officers or authorities thereof as to exercise any of such powers or discharge any of such duties given under the Act. Now, under Section 5, the delegation of powers is given. The central government may be notified order direct that the power to make order or issue notification under Section 3 shall, in relation to such matters and subject to such conditions, if any, as may be specified in the direction, be exercisable also by such officer or authority subordinate to the central government or such state government or such officers or authorities subordinate to state government as may be specified in the direction. Section 6 provides that the order made under Section 3 shall have effect notwithstanding any inconsistent therewith contained in any enactment or other than this Act, or any instrument having effect by virtue of any enactment other than this Act. It could be seen that this section does not either expressly or by implication repeal any of the provision of the pre-existing laws, nor does it abrogate such laws. The object of Section 6 is simply to bypass them. Thus, for example, an order made under Section 3 would be operative in regard to essential commodities covered by the textile control order. Wherever there is any repugnancy in that order with any existing law, and to that extent the existing law with regard to those commodities will not operate. The Calcutta High Court in Ramananda Agrawal versus State in 1951 had observed that the ultimate effect of Section 6 is that an order under Section 3 will override existing laws only on the ground that they are orders validly made under Section 3 of the Act. As rightly pointed out by the Patna High Court in Muhammad Anwar Hasi versus State of Bihar in 1955, that the Section 6 is a saving section which affords protection to the orders made under Section 3 of the Act as against the onslaught of any law merely by reason of inconsistency. Section 13 provides that where an order purports to have been made and signed by an authority in exercise of any powers conferred by or under this Act, a court can presume that such order was so made by that authority within the meaning of Indian Evidence Act 1972. Section 14 provides that on being prosecuted for contravention of any order made under Section 3 which prohibits him from doing any act or being in possession of a thing without lawful authority or without a permit or license or other document, such person shall have to prove that he has such authority, permit, license or other document as the burden of proof lies upon him. Section 15 provides immunity against action taken in good faith under the Act, which lays down that no suit, prosecution or legal proceeding can be taken against any person for anything which is in good faith done or intended to be done in the pursuance of any order made under Section 3 of the Act. Likewise, no suit or other legal proceeding can lie against the government for any damage caused or likely to be caused by anything which is in good faith done or intended to be done in pursuance of any order made under section 3 of the Act.